Go ahead.
Great. Good afternoon, Chairman and members of the committee. My name is David Goldman, and I am the Policy Counsel for the American Civil Liberties Union of Georgia. Throughout the years, the ACLU is known as a champion for free speech. This is a space that we have been in, and people rely on our special expertise. Accordingly, the ACLU of Georgia opposes HB 1274. Our primary concern is that this bill prohibits constitutionally protected speech and especially risks punishing criticism of the government of Israel. The line between criticism of Israel and discriminatory animus is too blurred to function as a law that could ultimately use to punish people for their speech. The IHRA's definition states that criticism of Israel, similar to that level against any other country, cannot be regarded as anti-Semitic. This language is unclear and unenforceable. The state of Georgia is not a Ministry of Information that decides whether certain criticism of Israel is similar to that leveled against any other country. For example, as a Jewish American who is frequently critical of recent Israeli administrations, I wonder whether my speech could be construed to run afoul of these restrictions. Or more likely, would a non-Jewish person making the exact same criticisms as me be considered anti-Semitic while I am not? That is the determination we are leaving to the state of Georgia to make, and that is problematic. This definition remains useful as a moral or sociological definition, but not as a legal one. Even the Office of the United Nations High Commissioner for Human Rights, the OHCHR, which has adopted the IHRA's definition as a working definition, has clearly stated that this definition is a non-legally binding definition intended to guide and educate. It is not a means to squelch debate or free speech, and those who misuse it this way should be opposed. Mr. Chairman, I also wanted to add a point of clarity regarding the bill sponsor, Representative Carson's comments earlier. He talked a bit about the adoption of this definition internationally. I just want to clarify there's a difference between being codified into law and being used just as a working definition to guide and illustrate. And I think in most of those examples you'll find it is the latter. And you know, in the way that IHRA's definition is referenced in this bill is also statutorily problematic. In a way, a sort of backdoor engrossment, meaning that the operative text, the IHRA's definition, is not spelled out in the law, but rather must be referred from a source outside the Georgia Code to understand what the definition of anti-Semitism is. This has several real consequences in how courts interpret the law. For instance, what if a court rules that part of the IHRA's definition is unconstitutional, but can't sever the problematic text from the code because it's not in the code? You know, the core matter here is that HB 1274 is an unnecessary piece of legislation because Jewish Georgians are already protected by the Georgia Code and the Civil Rights Act of 1964, under which numerous courts have held that Jews, whether actively religious or not, are protected from discrimination under the race and national origin language. The bill drafters have yet to identify a single blind spot in Georgia law where Jewish Georgians are not already provided the full protection of anti-discrimination and hate crime laws. It was suggested that prosecutors are choosing not to go forward with hate crimes in cases involving Jewish Georgians. Again, we have seen no evidence that this is the case. HB 1274 directs the government to consider anti-Semitism as evidence of discriminatory intent for any law or policy that provides for enhanced criminal penalties. However, under HB 1274, if a defendant's speech fits a controversial definition of anti-Semitism, such as legitimate criticism of Israel, the defendant's constitutionally protected speech could be improperly construed as discriminatory intent. Because crimes with serious penalties are involved, we must be cautious about the potential consequences. Ultimately, HB 1274 would have a chilling effect on constitutionally protected political speech. This committee should not pass legislation as drafted because it's unnecessary, and at the very least, this committee must reconsider incorporating the IHRA's definition of anti-Semitism in Georgia law. Mr. Chairman, we are happy to work with the bill sponsors and organizations interested to address the issues that have been raised today. If you'd entertain a motion to table this bill, that'd be great. You know, it's pre-crossover. There's still lots of time to work out the details. Thank you so much.
One question I have, when you talk about criminal penalties, unless I'm missing something, are there any other criminal provisions we have outside of our hate crimes law where this would come into effect?
You know, that's a good question. It's hard to know the exact application of this because there's so many places that this could reference in the code, but I'd be happy to get back to you with a more specific question to that. Okay,
because my memory of the hate crimes law is under Georgia law, you have to be convicted of an underlying offense, and then a jury in a separate trial will determine whether or not someone selected their victim, as the language is here, based on their race, color, religion, or national origin. If that's the only one, then I think the way I'd see this playing out, you can get back to me on this, would be basically a jury charge if you had somebody that was accused of discriminating against somebody because they were Jewish that would give reference to this definition, I'm assuming. And that would be something that could be used at looking at their intent. Is that your understanding of it as well?
For that, I'd have to get back to you regarding a specific question. But let me just also state that, this bill is not just about hate crimes context. It also has to do with anti-discrimination laws. It has a large potential impact. So I think we need to be considering, all the potential implications of HB 1274.
All right, you have some questions in the committee. Senator Jones?
Thank you, Mr. Chair. So it seems like, because with the anti-Semitism, you're talking about racism and religious, also discrimination. But you're kind of pulling it out and saying this is a specific kind of racism or religious discrimination. Do we have anywhere else in the law where we kind of pull out and say this is anti-black racism specifically, this is anti-Hispanic racism specifically? That, if you understand what I'm saying there.
I do. I am not aware of any other situation in law where we have that. I mean, my understanding is that protections for race, religion, skin color, national origin, those are sufficiently covered by the Georgia Code, by the Civil Rights Act. It is definitely unique to go in and do this. I mean, I guess one question we were thinking through is if you were to adopt a definition for Islamophobia, is there an agreed upon definition for that? How would you codify in the code for anti-blackness? So thinking that through, how that would be is interesting, but it's potentially problematic.
Senator Rett?
Thank you, Mr. Chairman. I was wondering if both sides would be reconciled to perhaps work together on the language before we take a vote and see if we can come up with a suitable solution to the differences.
As a committee, I think we will take this bill up in another hearing for a vote. So there will be time to do that. I'm not sure. This bill's gone to the House already. There has been some changes. I'm not sure if there's some language that your group would propose to add to it that would give you more comfort or not. That's something to think about, though.
Well, we definitely love to be involved in that process and provide any useful suggestions that can make this bill better.
All right, we have Senator Calzert.
Thank you, Mr. Chairman. You were talking a little bit faster than I can comprehend there at first, but you said something that in the bill that criticism of this would in no way prevent political discussion or freedom of speech. Is there a clause that says that? If so, isn't this argument kind of moot?
Well, for sure, Senator. Not sure I mentioned it specifically in my testimony, but it was mentioned earlier during this hearing about I think it was lines 50 to 53, saying that nothing in this code section shall be construed to diminish or infringe upon any right protected under the First Amendment. And I did want to address that because the question is, can the Georgia legislature pass anything that violates the Constitution of the First Amendment? And the answer is it cannot. And merely reciting that an unobjectable fact has no operative value. So from our perspective, that line gives away the fact that the bill trods on dangerous territory with regards to free speech. Okay. So we do have legitimate and serious.
But doesn't that kind of make it clear, though, that it doesn't infringe on your free speech? I mean, the thing, Israel is unique. It is a Jewish state. And so you're wrapping nationality, ethnicity, and your religion all into one there in Israel, and it's recognized that way worldwide. So I can see where somebody that's very anti-Israel is almost implicitly anti-Semitic. And the way I read this is it's just saying that can be considered by a finder of fact in determining whether you had discriminatory intent. If you're out saying death to Israel or whatever, isn't that implicitly anti-Semitic or against the Jewish religion and nation, which it's a nation state? I mean, it's such a ball of wax. I'm just wondering. I wondered if that lines 50 to 54 doesn't make it clear that you can be critical of political policies of that state, and this doesn't hurt you on doing that, but it also could be evidence that you hate Jewish people.
Well, unfortunately, that section is superfluous. If you wanted to make sure the bill doesn't run afoul of the First Amendment, the operative section of the text should be rewritten or altered. And I will say that the way you described, it gets to the point of the matter, whether being critical of Israel or kind of whether that is anti-Semitic or not. We're having the state of Georgia make that determination whether someone's speech is anti-Semitic. And say if I made that speech, I'm critical of the Naftali Bennett administration, I kind of doubt that people would consider that to be anti-Semitic, but maybe someone else making that statement would be. Is it really our position to have the state of Georgia, be essentially a ministry of information for policing people's speech here?
Okay, thank you.
Thank you so much.
Any other questions?